Okay, good afternoon. So my name is Fanny Couder. I'm the Deputy Head of the Supervision Enforcement Unit at the European Data Protection Supervisor. Welcome to this panel on navigating regulatory complexities when enforcing data protection in the field of AI. As you know, the EDPS has been entrusted with two different roles in this field. As Data Protection Authority, we're supervising the processing of personal data by EU institutions, agencies, offices, and bodies under the EU DPR, which is a GDPR for European institutions. And we have this new role under the AI Act as a market surveillance authority for the same institution. So let me approach this panel from the perspective of the traditional role of the EDPS, which is a data protection authority, which is confronted to the challenge of monitoring and supervising the data protection framework to the development, deployment, and use of AI systems, either high risk or not, but whenever processing of personal data is involved. So as you all know, the primary purpose of the data protection framework, as established in Article 1 of the GDPR, of the EU DPR, of the Law Enforcement Directive, is to protect fundamental rights and freedoms of natural persons when their personal data are being processed. So this basic statement and mission of this, or rationale of this, the data protection framework takes special and obvious meaning in the context of AI, as we all know the impact of these systems, not only on the right to privacy and to data protection, but in all other fundamental rights, such as non-discrimination, or a right to fair trial, to give just a few examples. And that's when it becomes necessary and particularly useful to build bridges with other regulatory bodies which have expertise and experience in protecting these other fundamental rights. And in order to engage into that discussion, today we have the chance to have three distinguished speakers. So, see from the program, the speaker from the AI office couldn't make it, unfortunately, today to this panel. But we have three speakers with whom we're going to discuss cooperation needs and strategies, as well as the relevance and limits of the existing tools at disposal of the regulatory authorities to make this cooperation a reality. So we have Sven Stevenson, Director of the Department of the Coordination of Algorithmic Oversight at the Autoriteit Persoonsgegevens, sorry for my Dutch, so the Dutch Data Protection Authority. Sven's department focuses on the impact that AI and algorithm have on fundamental rights and public values. The department coordinates efforts to strengthen cooperation among supervisory authorities. And they publish a risk report every 6 months on the state of play of AI and algorithm use and development in the Netherlands. Last edition contained a study into chatbots that are used by people for self-help and risk that it brings. And before coming to the Dutch DPA, Sven works with the Dutch Bank on the European Single Resolution Mechanism. We also have next to me Gaëtan Goldberg, who is a legal advisor to the President and Secretary General of the CNIL, the Commission Nationale de l'Informatique et des Libertés, which is the French Data Protection Authority. In this role, he provides strategic guidance. He oversees the development and coherence of DPA's doctrine, and he offers legal expertise on cross-departmental issues within the CNIL's cabinet. Prior to joining the CNIL, he worked as a digital rights and freedom expert at the French Ombudsman, specializing in algorithmic discrimination. He also worked as a data protection lawyer at None of Your Business. And finally, last but not least, we have Mila Vidina, who is a senior policy officer at Equinet, leading Equinet's work on AI and algorithmic discrimination with a focus on the EU's AI Act and related digital rights policies and legal initiatives, such as the Council of Europe Framework Convention on Artificial Intelligence, Human Rights, Democracy, and the Rule of Law. She was previously the lead of the unit of the Bulgarian equality body in international affairs. She worked for civil society organizations supporting refugees, the UN World Food Programme, and political campaigns in Bulgaria and in the US. She's a graduate of Princeton University Department of Politics and she holds a bachelor degree in political science and legal studies from Macalester College in the US. She pursued doctoral work on the interaction between the EU AI Act and non-discrimination law, and she has published on this topic. So let me get to my first question to you, Gaëtan. You have built an expertise on algorithmic discrimination both at the French Ombudsman and at the CNIL. Can you tell us about a case where the CNIL had to assess the impact of certain processing operation on another fundamental rights than privacy data protection, strictly speaking, such as non-discrimination? Can you tell us how it worked in practice? Have you cooperated with other regulators? And if so, under what framework?
Thank you very much. Good afternoon, everyone. Can you hear me? Yes. Well, first of all, it's a pleasure to be here. Thank you to the EDBS for extending this invitation. Enforcing other rights than data protection and privacy when you're working for a supervisory authority that deals with data protection is hard, because when we look for infringements of GDPR, or in our case, the French data protection law, we oftentimes find them. And so looking at other fundamental rights is taking an extra step. We have several avenues to do it within the GDPR, for instance, and that's something I'm going to talk about now. I think one of the cases I could draw here is a case that some of you are probably familiar with. It's the Parcoursup case. Parcoursup is the French platform that's used for candidates in France to attend higher education institutions, and it's a national platform where they make their wishes. They look at the universities they'd like to attend, and then they find out a bit later whether they were admitted or not. So what was the issue here? The issue was that you have this one national algorithm where they go on the platform, they make their selection, but then you have local, what we call local algorithms, with schools themselves having their own systems in place to then decide which students will be able to enroll in their programs. In this case, we had two sets of issues. The first one being, what happens to students when they face specific conditions? What about disabled students? So in 2019, we go back way back, but you'll see about it. Parcoursup is a saga; it's not a single case. In 2019, the Defender of Rights, the French Ombudsman, made an important decision where it pointed out that students who were suffering from a disability were treated as regular students, and which meant that irregular hours, not showing up to class, was considered, missing school entirely, and so they would not be able to attend the universities of their choice. So following this decision, the system was tweaked a little bit, and so now it's a little bit better for these students to be able to apply for these schools. And then the other issue we had to deal with was the transparency of the process and the discrimination via proxies. So the case went all the way up to the French Constitutional Court in 2020, which upheld the constitutionality of Parcoursup. And the reason was that you need to be able to protect the committees that are making those decisions when they select students so as not to cheat the system, as long as schools disclose the criteria and the way they're using algorithmic processing and the way they carry out these examinations. And so each year, it's this second part that takes some of the 16,000 complaints we receive. We receive many complaints relating to this issue because each school has a different mechanism and they might improve their algorithm or changing a little bit. And so that's where we come in. But when we audit these sorts of algorithms, there are several avenues to tackle non-discrimination law issues. We first can look at Article 5 GDPR and say, well, if it's discriminatory, it's unlawful. But we don't really have jurisdiction as a DPA to say this treatment, this processing operation is per se a discrimination and legally qualified as such. So you'll oftentimes see decisions that talk about risks of discrimination, which is a little bit fragile, to be fair. So we don't oftentimes go into this route. And then we can go on with Article 22 GDPR because it's explicitly stated in the French Education Code that you cannot have a fully automated decision to allocate a slot for a student at a university. But then how significant must the human intervention be? And so that's what we look at. We look at the human that makes the decision, whether they're empowered to understand exactly the application and whether they have the resources they need. If there's a suggestion by the tool that they're using to make that decision. And we look at confidence and selection biases, which brings me to my last point as an avenue for people to tackle fundamental rights issues that are not to do with GDPR, privacy and data protection, which is DPIAs, right? You can rely on DPIAs and ask controllers to use them to measure whether the system is biased or not. And that's something we emphasized a lot more now than we used to. So these type of cases require really, I think, a more holistic approach to enforcement, often involving interdisciplinary expertise. And so we tend to collaborate with other authorities, at least within the French circle, right? So we do cooperate quite a bit. In the Parcoursup case, we first gave an opinion to the executive, because as the French Data Protection Authority, we oftentimes give legal opinions to the government when they're trying to make a new law, and it requires us to give a legal opinion stated whenever data protection is at stake. And in this opinion, we sort of, raised a few flags and pointed out to issue there would be when dealing with transparency of the algorithm. But also, we cooperate with other authorities, and in that case, the Defender of Rights, the French Ombudsman, we've been working together on the issue, because while the Defender of Rights had their own decision, we had our own, we ended up working on the issue of algorithmic biases, and so we provided guidance together, and it's been the start of a new story where I think cooperation became a lot stronger since it's been a, how can I put that in? The Defender of Rights is a member of the CNIL, so they can sit at our meetings with a consultative voice. And so whenever we have issues dealing with algorithmic biases, since the Parcoursup case, we always spend a moment to talk about it and try and find ways to tackle them.
Okay. Thank you very much. Very interesting. We'll now turn to Sven. As head of the Department for the Coordination of Algorithmic Oversight, in charge of assessing the impact of AI system on fundamental rights, so has been mentioned already by Gaëtan. This is a task that requires a blend of legal and technical expertise. Could you tell us more about that work in practice? And in the same vein, do you need to engage with other regulatory authorities, and how have you put that into practice?
Yep. So maybe as a starting point, the way this department within the DPA has been set up, so the department that we set up 2 years ago, that is now increasing in size, and where we also have a strong link with the AI Act. We were really set up with the intention of preventing things going horribly wrong in the future. So we have very much a forward-looking perspective, where we also have ideally a primary focus to new type of algorithmic or AI systems, new type of use systems, and trying to understand them as early as possible, so that we also can intervene ideally in an early stage. So the early warning part of this, the early adoption, early analysis part of this is important. So clearly, the way we select the topics that we work on, the type of cases that we use on, at this stage, we don't exclusively rely on complaints being filed, or maybe other type of ways in maybe journalists uncovering certain items. We really try to discover those type of use cases on our own. So a lot of time, therefore, is spent on also just figuring out what we should be worried about. Mm. And that requires really a mix of people. So not only legal, not only technical, but for a very strong part, also people with more philosophical backgrounds, or people with maybe an economic background, or who have a background in behavioral science or in social sciences, just who really have a compass to think about, okay, this is something that concerns me, or people who are very much focused on younger people, childcare. For example, therefore, also just by engaging with everyone, talking to a lot of people, talking to scientific partners, talking to NGOs. One of the recent topics that we really looked into were these chatbots. And what we saw there was, and this was clearly an early stage type of research, we saw and we see this happening, that because of the combination of smartphones and large language models, you have this explosion of not only the large chatbots that you use for work, but you also have the more fun type of chatbots, which are the social friends or therapeutical chatbots. And you see the increase of those chatbots have been exploded over the last 2 years, and therefore the starting point was that for us was simply there just to test them as if we were users of them. So downloading them on some smartphones that we have, going through scripts, acting like we are a user, and then with in the back of our mind what we would be happy with from a GDPR perspective or a future AI Act perspective, for example. Very much interested in making sure that things are transparent, that the chatbot explains that it is a chatbot, that it is AI and not a human, that it is transparent, that there are safeguards in case something, or safeguards in terms of the output created. That was the angle that we looked at it, like ranking according to a yardstick of the output there. And then just from using it, we discovered a lot of issues there. And that's a way of working that we apply to other type of use cases there as well. Not necessarily ranking it or judging it against strict legal requirements that there are in place, but ranking and judging those systems according to the desirable characteristics that we see. And then in the end coming to a conclusion also for a broader system, right? So you don't just test one system, but you compare 10 of them at the same time and then come to a judgment how you overall feel towards those systems and to what extent you are satisfied or not with how those systems are being controlled, and you come to some general conclusions that you could follow up with individual action, but that also could lead to an understanding that maybe something needs to happen with regulation, that more focus of it is, and that could be yourselves, but it could could just as well be another supervisor, and that again is in each and every case really dependent on the very specific use case. So in this example with the chatbots, we saw a link with our market surveillance authority on medical devices, because in certain cases you could question if at a certain stage such a chatbot might reach the tipping point where it becomes a medical device, and then that regulator would be empowered under that framework. Clearly not the case in most cases with these type of systems, but we did engage with them. But in this example, you also have to look broader than just the pure supervisors. So we engaged also on this topic with the Dutch authority, who really is responsible for providing the mental health care in the Netherlands, and have their really expert perspective on how those systems are used.
Okay, thank you very much. So taking into account the interest of the patient as well, the relation between the patient and the doctor. Thank you. I turn to you, Mila, now. So coming from the Bulgarian equality body and now heading Equinet's work on algorithmic discrimination, the framework you're applying is non-discrimination law. Can you tell us about a case or situation where you felt that a demonstrated case of discrimination would be better addressed by a national supervisory authorities rather than going to court? And have you already engaged and collaborated with other national supervisory authorities in the past, such as data protection authorities, and under which framework?
Thank you for this question, and thank you for having us on this panel. We have been trying to reach out to EDPS for a while. In fact, we published back in 2020 our first report on regulating for an equal AI. So this was back in 2020, anticipating coinciding with the launch of the white paper. so before the AI Act was, and there in this report we had a dedicated chapter on data protection, because this is the vantage point that lawyers and also policy practitioners at equality bodies across Europe had. They had data protection as the toolkit, as the available toolkit at the time to investigate algorithmic discrimination. Just a preface. So I speak here on behalf of Equinet, which stands for a network of national equality bodies. So think of those as public non-discrimination authorities. Some states, so we represent, we're a network of 47 authorities from 35 European states, so we go beyond EU. And in many cases, in many cases, correct, states have chosen to have more than one equality authority. Yeah? So you would have one on gender, one on race and ethnicity. It's different in France, where you have consolidated it in one body. So the reason why I'm saying is because their mandates are varying. And recently the EU passed a legislation, it's called Standards on Equality Body, that tries to render uniform and harmonize those standards across European states so that most equality authorities, more or less, are able to provide an equal level of protection to those affected. And the reason why I explain this is because not all of our members are your classical regulator. In other words, not all of them are administrative bodies. Some of them have legally binding decisions as administrative bodies, similar to data protection authorities, but not all. Those are the minorities with legally binding decision. Then most of our members can go to court and they can litigate cases. Many of them have own initiative powers. So they would be able, and this is critical for algorithmic discrimination, they would be able to go to court ex officio at their own initiative in the public interest, and importantly, without identifying the victim. So, and this is a case, so when you have cases of structural systemic discrimination, having this power is important, right? So an equality body, and this has happened in some states such as Belgium, such as my own country, Bulgaria, an equality body could be observing through media coverage, empirical studies, etc., and identifying potential discrimination, discriminatory patterns of systemic nature. Let's say we're talking about racial segregation that is embedded in institutions such as the fire brigades or the police force. And they could, if they have the powers, bring this case without having an identifiable victim. So, and this is a big problem, obviously, with algorithmic impact on human rights, is how invisible they are, the opacity of the system, and the scale at which this potential algorithmic harm to human rights operates. So having this power, tackling systemic discrimination without putting the burden on the potential victim, let's call it this way, that's the lingo of EU law, no discrimination is victim, not a rights holder, is important. So in those cases, then what advantage would it give you to go to an equality body with or without legally binding decisions? Well, the speed of the proceedings. So if it's a legally binding decisions, then you would have, it would take on average considerably less, given the court backlog. It's free of charge. You would be provided with free legal support. So you would be provided support that would help you also with your case, should you be able to bring those cases to the equality body itself. Now, you might ask, oh, isn't this a conflict of interest? You know, the equality body is supporting a rights holder, but at the same time also handling the case. Well, those will be separate departments, and I think that's a reason why you might want to turn to an equality body, is because the organizations work on the presumption that we have an imbalance of power to start with. That's a major assumption of equality, right? That's why we have this procedural safeguard shifting the burden of proof within non-discrimination law, which we do not have under data protection law, precisely because we depart from this unequal playing field. So those are some reasons why, and very concretely, for example, we had a women's rights organization in the Netherlands, which is part of the Global Witness Network, bring a case to the Dutch Institute for Human Rights, and we had a webinar with them, and we asked them this question: why did you choose to go to the Dutch Institute and not to the Data Protection Authority? Because data protection law normally, and authorities, they have bigger sanctions in the majority of European jurisdictions. You have bigger sanctions. You could have also stronger enforcement powers, because in some member states, equality authorities, unlike data protection authorities, might not have investigative powers. So it was not an intuitive decision. And the answer we were given, and that's on record, is that because of the support, the legal non-discrimination expertise, they were able, so they wanted to handle the case from the vantage points of non-discrimination and upholding the equal treatment and kind of substantive equality principle. And because it was also faster, like than, for example, going to court. And of course, the accessibility, the financial accessibility aspect was also one that was addressed. And then I could also mention where else we have, so we heard the case of France, which is in somewhat a privileged position. So first of all, let me say that, I had the pleasure of working with Gaetan briefly, but I do remember you providing input when our first submissions on the Act, and there we said, wow, the fundamental rights impact assessment, which did not exist in the Commission proposal, but the fundamental rights impact assessment should be fully aligned with data protection impact assessments and should be mandatory across all risk levels. Well, little did we know this was 2021, 2022. Anyways, but France is an outlier insofar as you have structurally, institutionally embedded this cooperation between an equality authority and a data protection authority. And to the best of my knowledge, it's a precedent, doesn't exist elsewhere in Europe. But what we have seen as you could even argue it's a trend, because it has happened already in 2 European states, and I've heard about similar discussion happening elsewhere, is data protection authorities working with equality authorities, also consumer protection authorities, is part of regulatory sandboxes. It seems like regulatory sandboxes could provide particularly opportune ground for kind of cross-fertilization between those fields and collaboration. This has happened in Norway, for example, where the Norwegian non-discrimination ombud has worked with the data protection. He was actually invited by the data protection authority as a part of the piloting, and now it's out of pilot of the country's regulatory sandbox. And they worked on a couple of cases. One was with the hospital, where they prevented or tried to identify a potential racial discrimination for patients that were accessing high blood pressure measurements in a hospital, in a public hospital. So the public hospital was procuring. Please excuse me, it's my ignorance what exactly it was. So it must be some kind of a medical device. So I'm sure the medical device regulator must have been there as well. And then we have a similar example with the Information Office in the UK and the UK Equality and Human Rights Commission. By end of April, they should have released or would soon publish 4 case studies based on real-life examples with private and public developers of AI systems that together with the Information Office, they try to tackle the data protection and also equality implications in recruitment, in the healthcare sector. Law enforcement was one case, and the 4th one escapes me, but I'll be happy to provide you with more information. And then our members have also contributed, for example, in Slovenia, they were revising the law on data protection. This happened during COVID times, and our Slovenian members said, okay, you have to insert specifically a reference to non-discrimination law whenever the data protection impact assessments are carried. So we want to get information also specifically on that. In theory, you should be able to, right? Because they can't cover fundamental rights, the data protection impact assessments. But I think that the targeted reference to non-discrimination law, as was suggested by our Slovenian member in the amendment of the Slovenian data protection law, is a good example. Where, yeah, I could think of other specific examples, but conversations are mushrooming because the data protection community has a rich experience with tackling algorithmic harms to human rights, which our members didn't have back in 2019. So we started looking at what data protection authorities have been doing, but we could not find many cases in Europe that data protection cases that had clear equality implications, but they were decided solely on data protection grounds. And we thought this was a loss. So we are encouraging our members to also team up with their data protection authorities. And we actually had a study visit at CNIL, where our members got to meet colleagues at CNIL. And now as part of this encouragement, please do reach out to your data protection authorities. And now Equinet is participating in the Joint Technical Committee 21 for developing harmonized standards for the AACT, and CNIO is an ally there, so the French Data Protection Authority, and we also have good experience with the Dutch Data Protection Authority. I think you have a colleague of yours active in data bias and data sets, technical standards. Oh. So within there, we are also, I think, forging some hopefully effective partnerships. So,
thank you very much. So I would like to follow up on this, on how to build strong and effective cooperation channels. I heard that in France it's quite advanced, as French Ombudsman is structurally part of the CNIL, even though you mentioned regulatory sandboxes. You refer to more cooperation with other equality bodies. I would like to refer, I mean, we have the AI Act, which is the first regulation that is the first to explicitly at least set up some cooperation or obligation to cooperation channels between regulators. So in two articles, Article 77 and 79. So 77 grants the powers to national public authorities and bodies which supervise or enforce protection of fundamental rights to request and access any kind of documentation created and maintained under the AI Act, but only in relation to high-risk AI system. That's the limitation. Or to request even the Market Surveillance Authority to organize the testing of this system, so which would link to your example of regulatory sandbox. And on the other side, we have Article 79, which require market surveillance authorities to inform and fully cooperate with the relevant national public authorities when they identify a risk to a fundamental rights. So that's one piece of legislation which tries to put that within the scope of its application. We also have the ruling of the Court of Justice of the European Union, I'd like also to mention, called Bundeskartellamt, where the court was asked, it was between whether competition authorities can find that a practice not in line with the GDPR could be taken into account, or could they assess this practice in the context of the examination of an abuse of dominant position. And here the court has recalled that there is a general principle of sincere cooperation under the Article 4.3 of the Treaty of the European Union, under which administrative authorities must assist each other in full mutual respect in carrying the tasks which flow from the treaty. And the court clarifies as well what it means in this context: the obligation to consult the other authority and seek their cooperation in order to dispel any doubts or determine whether it must wait for the other authority to take a decision first. And on the other side, to have that authorities an obligation to respond to such requests for information or cooperation within a reasonable amount of time. The court recognized that each authority should act in the context of this specific framework, because there are different policy objective under which so competition law and data protection law are based on different rationale, and they recognize this. But it was one of the first cases where this interaction was discussed. So I would like to ask you, in order to dig a bit deeper in this topic, do you think that these cooperation channels are enough? Would you use this prerogative? Which are their limits? Which are their advantages? Do you think it can leverage or open new way of cooperation to the example you have given already in the first round of questions? So maybe start with you, Gaëtan.
Absolutely. I think these cases came in very handy. I'll touch upon the CJEU case first, and then I'll talk a little bit about the fundamental rights impact assessments. When you look at the Meta platform case, which involved the Bundeskartellamt, it's very handy for us as a supervisory authority to find out that what we've been doing from the very beginning, which is talking behind closed doors of these cases with other regulators and working together, has found some sort of a procedural solidification in a way, right? It's stronger, and the decision you'll make referring to other pieces of legislation that are not only yours is going to end up being legally sounder. The way we cooperate with other authorities nowadays is either quite informal in a way. So we oftentimes refer cases, for instance, when we find out something that's very bad and criminally, that involves criminal law courts, we will refer it to the public district attorney's office. And that's something we do in other areas. For instance, if you look at competition cases, we sometimes refer cases to the competition authority. But these things until now were sort of, informal. You need to know the person working there. There needs to be good relationships between these institutions, politically speaking, as well. And the fact that it's being sort of made in a procedural way makes it quite more meaningful, I think, in the long term. Talking about a clear example of recent years, we have a protocol with the DGCCRF, which is the Fraud Control Directorate in France. So basically that handles consumer law issues. And you'll see that when you look at consumer law issues and data protection, there are areas where there are overlaps. If you think of dark patterns, it's an area where you want to have a proper consent mechanism for a cookie banner, but also it might be unfair commercial practices to have this in place. And so the fact that we have these protocols to be able to not only talk to each other when a case arises, but also sort of have shared trainings, opportunities for our agents at the DPA and their agents to come with us and sort of brainstorm through all of this, makes it possible at the end of the day to have better decisions, and these decisions are stronger when they get attacked in courts. But thinking of cooperation more generally speaking, I think the whistleblower directive is quite a good example. When you look at the way it's been, the way we've done it under the French legal system is that you have a central authority that's taking all of these cases that touch upon some whistleblower case and issue that can deal with any fundamental right, so to say, and one authority, the defender of rights, redirect these cases to the authority that's supposed to be in charge. So in a way, it's a bit of a ticket system, and it works super well because all these authorities sit together, talk about these cases, and realize where they are building bridges to be sort of made. And when we talk about the AI Act and fundamental rights impact assessments, I think looking at only Annex 3 and high-risk application is quite dodgy because we have to deal with all of the other acts and all the other options. So I think it's a good start to sort of implement these cooperations, but we need to think further already and sort of implement similar mechanisms in all of the other cases.
Thank you very much. So I take note of need for formal cooperation mechanism for better decision making. I think that's Sven, would you like to comment on that?
Yeah, no, I mean, mostly echoing, I think, what Gaetan mentions. The most important thing is removing any potential legal barriers that there are to cooperation. But quite often, also based upon my experience, people talk about limitations or are concerned about limitations, and in practice then you don't really end up seeing them in the end. And I think the Bundeskartellamt case in a certain way confirms that. Before working then with the DPA, as mentioned in the introduction, I worked in financial sector supervision for a very long time, and there you really deal with very sensitive data, financial sector data, which potentially has a very big impact if any of the data gets out. So that's very strictly guarded, and even there is a lot of potential for cooperation. From a legal side, there are no barriers to cooperation, but then by far, and also to make the whole principle of what is in there in the Bundeskartellamt, to make that work in practice, and And the whole idea behind this is, as one supervisor, you do a certain investigation, and in order to move a step forward, you need to have a judgment from the other supervisor on a certain part that is of relevance for the argumentation that you need to make. And in order to move forward, you want to have an answer within a particular amount of time. So within 1 month or 2 months, you would like to have an answer so you can move forward with your investigation. Now, that can of course be quite challenging if suddenly I receive a request from another supervisor and I need to answer it within 1 or 2 months. But therefore, what is extremely fundamental for cooperation is to have a supervisory culture and to have a supervisory community where you work together in the digital domain. So it should really be within the DNA of certain organizations that you meet up a lot of times, that you have a lot of informal context, that you know these people, that you don't suddenly receive by surprise a request that you need to answer within a month, but that's, and in most cases, this can be this is the realistic story, that you already know a few months in advance that there is a likely chance that you might need to look at it in a few months ahead, and in many cases also at the very early start of looking into a certain topic, that you already start discussing and checking with your partner supervisors how they look at the topic. And also what increasingly we see, and of course since a few years we are really increasing the cooperation and the networking and having meetings together with supervisors and having that on a structural basis on board level, but also on managers level and at the workflow level. For new cases, also having a discussion at first instance about who should look at this, and increasingly with all the different layers of digital legislation, this will be increasingly the questions that we will have to discuss. And you can see, of course, this emerging with, for example, the triangle between the Digital Services Act, the GDPR, and the AI Act. In the end, all of them touch upon big tech companies for a large part, and strongly interlinked with each other. So you want to discuss that together. Also then increasingly, not only on the national level, but also on a cross-border level. So those are at every stage of dealing with certain topics, are the type of things that you need to look into. One thing, and maybe in a year time we can come back on that. One thing that we are experimenting with in the Netherlands is also to set up, I would phrase it, joint supervisory visits. So different, multiple digital regulators teaming up in organizing meetings with supervised entities, in order to also, from that perspective, enhance that we have the same knowledge about where these companies are heading, what they are doing, and so we can really, at the early stage, come up with a joint perspective also about how we view those developments. Mm-hmm. But the most important thing is culture and community, and this is what you really need to work on. Yeah. So organizing meetings, workshops, knowledge events, having these people have drinks, but you need to have a community, because that is what makes supervision effective. I will keep emphasizing that.
Thank you. I'll take note of having drinks to have an efficient supervision. No, I like the idea of this joint supervisory visit as well. I mean, we're trying to implement that in the field of data protection at EU level when we have cross-border data processing activity in the public sector. And we have found that from the EDPS it's very useful actually to be able to exchange, to have this different point of view. So, and also to set up a common view and vision on what you were saying. What is to be supervised, which are the stakes, and how we're going to go about it, depending on the also different scope of competences. So Mila, now I turn to you for the last word on this question.
Yeah, sorry. Same question for me? Okay. Oh, it's
Same question.
a pleasure. I'll take it from community and culture. So, and when we talk about community and culture, and since I come from equality, the equality area, my question is who is in and who is out. And I come from the non-discrimination sector. It's not clear what culture we're talking about. There is you could argue that there is a certain still existing division or even tension, arguably some might say, between digital rights and human rights, classical human rights. And we come from the public sector, collective, independent redress, human rights community, and it is right. We're all in the same, but we are not digital regulators, and this is not our pedigree historically as well. Non-discrimination and equality law. It comes with a proud civil, political, but also socio-economic empowerment. It's a different history, and different rights are at stakes. So how do we integrate newcomers in this ecosystem of digital regulators, if we, meaning equality authorities, human rights institutions, ombuds institutions, are to become also digital regulators? And the AI Act forces us to do that, or rather, it doesn't force us, reality confronts us and forces us, but the AI Act provides potentially a toolkit or some leverage for us to act that, because it addresses also risks to fundamental rights, which is we do not have as explicitly, and the DSA, even though there you have fundamental rights impact assessment, and you have a more limited take on it through a data protection lens. It's not the whole range of fundamental rights. So the AI Act and the DSA, and now through the links of those with the GDPR, also the GDPR ushers us into that community. And there's some, because you asked a question about limits, and I was thinking a classical conflict of rights, right, is data privacy versus non-discrimination. And you see this in Article 10 of the AI Act, where you would purportedly need to have access to the training data in order to uncover and detect possible discrimination, to prevent it really. So you would be carrying out bias audits. So you would need to have access to categories of sensitive data. So how do you balance those equally legitimate rights, right? This is, and this question becomes even more complex when we take it outside of the regulatory sphere and move it ex ante at the level of design and development of products, when organizations that develop AI systems and they develop their risk management system and develop their quality management system have to decide how to address those rights, right? Because they need to identify what risks to fundamental rights as per the AI Act are implicated, and they have to do this in order for their product to enter the EU market, if they want to. This is the whole idea of harmonized standards underlying the compliance obligations under the AI Act. So developers, providers of high-risk AI systems would have to engage with this juggling exercise when they implement technical standards in order for their products to get a CE, safe market, and for their product to enter and circulate in the internal market. So this is just one potential maybe dissonance between non-discrimination and privacy that's possibly exaggerated. Now, how is this to be solved? It's about communities of shared practice and kind of cross-fertilization and meeting. And this has to be institutionalized and formalized. And now we have, again, this mushrooming of enforcement structures, AI Act, but we see that the Market Surveillance Authority, even though the deadline has not passed, market surveillance authorities could be, and in many cases are discussed to be, data protection authorities, consumer protection authorities, and then also the authorities, digital communication, audiovisual authorities, which are under the Digital Services Act, are also mentioned, or in some cases going to be listed as the market surveillance authorities. So you have basically this patchwork of different supervisory authorities under different digital regulations overlapping. And it's a timely, we have the momentum, we have the kind of the legal prompts, the reminders, the occasions in the law to institutionalize some platform at national level, systematically, state by state, where there are regular meetings of those regulators, including us in the, let's call it, classical human rights community. I don't like this division, but it exists in practice because of the way the landscape institutionally is structured. So I think we should be mindful of that, and it's only through investing resources, states investing resources to launch those platforms and to organize periodic meetings, it would work. And the article on market surveillance authorities is 74, I forget the numbering. It's I think paragraph 10, which of the A Act, which mentioned basically addressing states, saying that collaboration shall be enabled between the market surveillance authorities and other relevant authorities. And by other relevant authorities, it's mentioned other relevant authorities also for the implementation of the A Act. And just looking at the list of use cases in Annex 3 of the EU A Act, you see that this is the whole scope from, financial regulators, labor inspectorates, through competition authorities, actually.
Yeah.
So.
Maybe just to add from our perspective, so in the way that we cooperate with digital supervisors in the domain of AI and algorithms, the Dutch Equality Body being the fundamental rights authority that we have, they are a full-fledged partner as we see it.
No, it's an exception, though.
Yeah. No, they are a full-fledged partner in how we want to cooperate in the digital world. So they are an extremely important player in that regard. But they need more capacity. So that is also, in the way we look at it, we are also advocating in, of course, us being of having sufficient capacity, but also our partner organizations who we work with.
Yeah. Thank you. I was wondering, maybe this requires as well equality body to develop new skill, not kind of skill, not to detect new kind of discrimination. Is it a bit also one of the challenges from your side then?
Yeah, you said new skills or new kinds of discrimination? I just didn't hear.
No, new skills in order to be able to detect
absolutely.
Discriminations.
That's Equinet, us as a network, that's one of our core function is to empower them through capacity building. So, our team, this is what I've been doing and my colleagues, first and foremost, have been doing for 6 years. So we've launched, every year we have several trainings, and we are trying to bring also software engineers and data scientists into the room. And through this, actually what allowed us to be engaged with, harmonize with the development of the future potential harmonized AI standards for the EU Act is an academic, publicly financed project from the UK. Sadly, the EU does not give money to, and it's that UK project that through that we launched a series of trainings, and we also try to bring in capacity in terms of technical capacity from standardization fora. And educate our members, but we also opened it up to civil society. We launched I think it was in April, we had 3 webinars, Equality by Design, Deliberation and Oversight. So going kind of a technical explainer, demystifying basic, what is an AI system, but with a specific equality lens, and also very pragmatically thinking about what are some measures that exist in terms of technical measures, but also what are some organizational measures if you develop or deploy AI systems, really, that you have to be attentive to, again, from a non-discrimination and equality perspective. And this series of trainings builds upon ones we've done in the past. But I have to say that it's difficult also to find trainers, legal scholars and or practitioners. We were lucky and we managed to have actually 2 experts who have legal degrees, but also happened to be software engineers, or in one case, cybersecurity engineer. But this is preciously rare, and I think it has to do also broadly with how our society has socialized us into silos of expertise, and some types of expertise are more valued than others. Yeah. And you see this with technical standardization. Your arguments have one weight if you come from a legal human rights perspective, and a different weight if you come from a data protection legal perspective, and a completely different way if you come from a technical perspective. So it is a hierarchy of competencies and expertise. And I guess it's normal in any domain of knowledge, but it's something to be aware of, especially as we mingle different cultures, to have this broader openness to
But then from what I hear, to finish on a positive note and before opening the floor, I really have the impression that we are learning from each other.
Yeah.
Actually, and I mean, what we learn in one field is helping the other field, and vice versa. If I hear you talk about equality by design, as we have worked for a very long time on data protection by design. So, thank you very much. So I'm going to open the floor to questions. Okay. Yeah, and then in the back.
Hello, thank you very much. It was a very interesting panel. I have a question for Gaetan on a more practical aspect, like based on the case you referred on Parcours Up case, I'm thinking of several AI-related companies that create tools that are going to be used on the workplace environment or in education by doing this ranking via an algorithm of students or of applicants for specific jobs. And then these companies offer their services or their tool to other companies that they're going to use them. So we're talking about AI providers, most probably high-risk AI systems, right? And then the companies that are going to use them are going to be the deployers. So there I wanted your opinion about how these companies acting as deployers and probably data controllers from a GDPR point of view, how they're going to approach the discrimination on the algorithmic discrimination based on a tool that somebody else has created, and what is, in your opinion, some 5, let's say, top priorities or requirements that they need to check before engaging with these companies?
Do you want to have other questions? Or should I? Okay. Cool. Thank you very much for your questions. Very insightful. To be fair, as a data protection authority, we will take a look at the company that's developing the software as well as the controller at the end of the chain. We have released a number of guidance sheets on AI on which we list up the requirements that we think should align with GDPR as an AI provider. And when it comes to high risk itself and non-discrimination, that's what I was pointing out when it comes to DPIAs, basically. So within your DPIA, you should be able to point out whether there's a risk of discrimination and what are these biases and how you measure them. So that's the one thing we will take a look at if we are to audit that company. Then again, I can't really give you the specifics because we are drafting this as I'm speaking.
Okay, so we will get like a methodology on where we draw the line, because normally one company might say, I might stop here and I'm going to accept residual risks X, Y, Z. But are these risks acceptable for you? That's the question, I guess, that everybody's asking around.
I think this works on a case-by-case basis. It's very hard to generalize. And when we look at a discrimination as a DPA, we can't really, like I was saying, we can't really say it is a discrimination. So we'll have to ring up to our buddies at the French Ombudsman, the Defender of Rights, analyze the situation, and then at the end of the day, we might end up with one.
Okay, thank you very much.
Yeah. Question on the back.
Thanks so much. Very interesting panel. I have a question to all of you, because you are mentioning a lot this different manners of cooperation, and I was just wondering whether institutionalizing and formalizing this cooperation is something you would wish for, and if yes, on which level. And so I was particularly curious because from what I understand, this personal interactions are very important for you in this field. So and also judging from the experience that you probably have with the GDPR one-stop shop mechanism, that's very formalized. I was wondering what you see as a potential leeway here, and to what extent this formalization is necessary. And again, like which level, European or national? Like what's the way out of it? So yeah, thanks.
The way out. Please. Who wants to take the question?
I think you need a little bit of everything. So yes, things need to be formalized, But the biggest risk is that you are trying to make this way too complicated. Because you can easily spend 10 years on drafting cooperation agreements. And this is not a joke. And trying to cover every potential scenario is what could happen in certain type of interactions. And then by the time that you finish drafting your cooperation agreement, then some new laws have been created, and you need to revise it all over again. Now, therefore, some fundamental principles need to be realized in order to enable cooperation. Again, as I mentioned, you should be very careful that you don't introduce unnecessary limitations for cooperation. And then, like I mentioned, it is a balancing act indeed that requires to also have. So other than having this culture and community, also have a good, also on a board level, for example, have a good understanding that you are able to reach agreement. For example, if you want to do a joint investigation, or you want to rely on the expertise of another organization, are you able to come up with a way, for example, if this is very demanding in terms of time, that you can compensate the other supervisor for the time being spent on this, because in the end, the supervisors also have limited resources. So these are the type of barriers and restrictions that you need to look into, that they are not there, remove them as much as possible, enable a system where you ensure that these supervisors meet from time to time. And some of these new digital legislations, they enable already those type of cooperation mechanisms. So, for example, also within the Digital Services Act, it automatically comes with a rule that different type of supervisors involved on a national level also have to come together. That is what I think is necessary there. And in those cases also, it also doesn't only have to be bilateral agreements that you reach, but you can also work on multilateral agreements. So you have one big agreement that all type of supervisors can jump on board in order to be part of the cooperation. And also take this step by step, right? So you can try working on agreement and on framework, and then after a year, if you run into things, you can work on a next version of this. Also make it a bit learning by doing.
Make it easy on the organizations that are that you're convening, and by make it easy, I mean having the state. So do not make it incumbent upon the regulator and straining their already scarce resources. So as a government minister or whatever, no, I guess if it's a multi-party and if it's several regulators, it has to be again at a high level, so above ministerial. So find a structure which is managed outside of the regulator. And just regularly convene, I don't know what frequency, this is too prescriptive, but find a light touch way just to bring together in the same room. I think regulators, this should be good enough. I was looking in the room to see colleagues from the Belgian equality body. We have two, one is UNIA, the other is the Center for Institute for Equality Between Men and Women. I know, for example, that both of those bodies work on hate speech and hate crime in the case of the Institute, and a practice which seems to be pretty low effort and light touch practice is just for, is it the ministry that convenes them? But basically they get together with the prosecutor's office, with law enforcement representatives, with civil society organizations that work as trusted flaggers. So this was under the codes of practice, now it's been transferred to the Digital Services Act, right? And probably I'm missing some other parties, but they bring together different stakeholders in the whole hate speech and hate crime monitoring, so it also has a criminal dimension, and they meet regularly to discuss cases. Like, I don't know how regularly, but I heard from them it's an effective system. It's because it just puts everybody in the same room periodically, short meetings, exchanging information. And this already helps you. So national level, I think light touch, do not put the burden with the regulator. European level, I actually think, and us as Equinet, I just haven't had the time to do it, but we really, as our priority for this year would be also to call for a European level coordination platform. And I think the AI Act gives us some ammunition there because the article on the AI board, and for that matter, the same for the AI forum. So the AI board being the pan-European body that links the national public authorities and competent authorities. It has a provision on temporary but also standing subgroups. And I think that fundamental rights, and in particular Article 77, which refers to national public authorities that supervise the protection of fundamental rights law, putting those national authorities, the fundamental rights authorities, together with the rest of the more familiar landscape of digital regulation, so the Market Surveillance Authority would be there, would be useful. All of those are national authorities. Sometimes it's easier to do things at the European level than it is at the national level. And I've discovered this through my own experience. Sometimes I used to meet, colleagues from the Ministry of Justice or International Affairs here, and you work in your silos at the national level. But if you happen to be at an event, let's say, a real example on hate speech or hate crime in Brussels, and you start talking, sometimes it's easier. And again, this puts the burden away from the national regulators. It might provide, by the way, an extra justification for those regulators to give their staff an extra day. Okay, you're going to Brussels, you have that dedicated time. So AI board, using the subgroups mechanism and having a dedicated one that brings together Article 77 with the market surveillance. That's it.
Would you like to add something?
Yes. Just to say, it really depends. If you're dealing with a specific case and the case needs a solution and you don't have a formalized cooperation mechanism, then it might take forever and that person will never see the end of the day. So you might have formalized some things and other things need to be a little bit softer because you don't want a higher burden on something you're trying to achieve with your partners. I think, to summarize, we need to develop joint guidance and tools. That's something we've all said. We need to formalize some cooperation mechanisms and have joint task forces, regulatory sandboxes between DPAs and equality bodies. We talked about that as well, but also other relevant regulators. And we need to invest in capacity building and knowledge exchange. I think that's the main point of that discussion.
Thank you. Is there any other question? Yes.
Thank you for this panel. Just a question for all of you. So the EDPB and the AI Office are working currently on the guideline on the interplay between AI Act and GDPR. So you talk about the importance of having guidelines. What do you especially expect from those guidelines? Thank you.
I'm the moderator.
I mean, you can go, because it was about the data protection. Otherwise, I have a take on that too.
You start. I'll jump in later.
You're talking about the article, so the Article 96 guidelines, right? That are about the relationship between this regulation, the AI Act, and other applicable...
GDPR.
No, but it's not only about GDPR. It's a broad formulation. Like the article, there is one. So the Commission has to develop guidelines that are about the interface and the relationships between the AI Act and other relevant laws. So this is maybe separate from what you're referring to, and it's that guideline that we had in mind for non-discrimination law.
I don't. The question is about the ongoing work, no, on the guideline, the interplay between GDPR.
That's different.
And
That's a different.
AI Act,
Sorry.
If the guidelines are still being written, I can't really comment on their content, but if you go on the CNIL's website, you'll see that we published a lot of material dedicated to that interplay.
Yeah.
I think, I mean, the overarching story is, I think that it's very welcome and extremely important that people understand how strong certain linkages are, and that they reinforce each other. So, I mean, it's in a certain way, a very exciting journey that as supervisors we have to go through, because some of the concepts that there are within the GDPR and the AI Act are so strongly interlinked. And this goes beyond, for example, Article 10 on data, which embodies some of the tensions that there are. But so that's one part of the story. The other part of the story is how the AI Act relates to the data privacy impact assessment, data protection impact assessment. There you see a strong link. But of course, overall, you also have these very strong links when it comes to explainability and transparency. So Article 22 of the GDPR, that has its full effect in the end on any AI being used. And you also have in the GDPR in the AI Act this article on the right to an explanation, which very strongly links to the GDPR. And then of course the GDPR will always have a broader scope. And increasingly also in the work that we do, where our starting point is, okay, we see AI or algorithms being used in society, and we want to know if we should be concerned with that. Our starting point with that type of work is really risk-based, early warning, understanding it. It's not taking the GDPR as a starting point. It's not taking the AI Act as a starting point. It's taking the system and the applications as a starting point. And increasingly, we also remain worried or concerned about very simple algorithms being used, which are not AI systems. So strong similarities. So therefore, very good that this work is going on, while at the same time, the supervisory mechanism and the regulatory framework is extremely different. So these concepts seem alike and overlap with each other and are interlinked with each other, but keep in mind, and we could spend days on this, that the AI Act is product supervision by market surveillance authorities, and therefore has a completely different purpose and a different way of working. And what that means in practice, that is really where also these guidelines hopefully should be helpful. Not only these guidelines, but many more that will need to be there in order to increase our understanding.
Thank you very much. I think that was the idea also from the ruling from the court, where each framework must be assessed in line with its own rationale and dynamic, and maybe they could meet, but where do they meet and how do they meet? That's
yes, and maybe also to add there that it's going to be extremely helpful if for one piece of legislation we benefit from the increased understanding of other pieces of legislation. Now, I'm not going to dive into that, but I think that, and if you're not familiar with it, look this up. The guidance, the explanation given by the European Court of Justice on the Dun & Bradstreet case, which is a GDPR-related case on how transparent you should be on the outcomes of an algorithmic system. That's GDPR case law. Extremely relevant, and it provides a lot of answers for things that we still need to find out or make more clear for the AI Act, because it will have to be aligned anyway. And that, I think, is how these different type of legislations can really benefit from each other. And it's also up to us as supervisors to provide the overarching and the complete holistic picture for in the end, organizations that need to deal with this.
Thank you very much. I think we reached the end of the panel. Yeah.